Hello friends, welcome back to our channel Legal Nexus. In today's video, we are going to discuss the concept of liability. The term liability is very important in law because it determines when and how a person can be held responsible for their acts or omissions. In simple words, liability means the legal responsibility of a person to answer for the consequences of their conduct. It ensures that right and duties are balanced in society. In this session, we will understand the meaning of liability, its nature, and why it is considered one of the fundamental concepts of law. When a person violates the right of another or does not perform his duty with respect to is committed and therefore another. The wrong is committed and therefore liability arises. Liability is the remedy for wrongs where there are wrongs committed, the liabilities arises. Thus a person committing wrong is liable or responsible for it. Definition and nature of liability. The word liability refers to the state or fact of being responsible for violating a law. If a person violates another's right or acts contrary to his duty, he will be responsible for such violation. The responsibility resulting from the violation of law is termed as liability. In jurisprudence, liabilities can be classified into civil and criminal. Civil liability. Civil liability refers to the legal responsibility one person or entity may have towards another in matter related to non-criminal issues. It arises from violation of civil law or regulations, typically involving disputes between individuals or entities over issues such as contracts, property rights, personal injury, or family matters. When someone is found civilly liable, they may be required to compensate the injured party through remedies like monetary damages or specific performance. Civil liability cases are usually initiated by private individuals or organizations seeking compensation or resolution of a dispute. Civil liability. Civil liability pertains to the legal responsibility an individual or entity bears for the action that violate criminal laws and regulation established by the government. Crimes are generally offenses against society as a whole, and the government, represented by prosecutors, initiates criminal proceedings. If someone is found criminally liable, they may face penalties such as fines, imprisonment, probation, or other punitive measures. The purpose of criminal liability is to punish the wrongdoer for violating laws that are intended to protect public safety and order. Thus, there are two essential conditions of criminal liability: actus reus and mens rea. Mens rea or guilty mind. A prohibited act will become crime when it is accompanied by a certain state of mind. There must be a mind at fault before any crime can be committed. An act or omission alone is not sufficient to constitute a crime. The act or omission should have followed by an evil intent. Thus, we may say a crime equal to a prohibited act or omission plus guilty mind. The combination of an act and intent makes a crime. An act by itself is not a wrong. An act done with guilty mind makes it criminal if the act is prohibited by law. Mens rea is an evil intention or knowledge of wrongful of the act. Actus reus may be negative or positive. X shoots Y and kills him. It is a positive actus reus. The mother of a child does not feed the child and causes the death of the child by starvation. The actus reus is negative. This actus reus in this illustration is omission to act. In order to be liable for a crime, the act or omission should be one prohibited by law. Theories of liabilities. Various legal theories underpin liability, including strict liability, holds individual or entitled responsible for harm caused, regardless of fault or intent. This is commonly applied in product liability cases. Joint and several liability. In cases involving multiple parties, each defendant can be held individually responsible for the full extent of harm, allowing the plaintiff to recover the entire amount from any one of the defendants. Vicarious liability imposes liability on a party for the action of another, such as an employer being held responsible for the wrongful act of an employee committed within the scope of their employment. So, this was an overview of the meaning of liability in law. We learned that liability is nothing but a person's legal responsibility to answer for wrongs committed or duties neglected. It plays a key role in maintaining order and justice in society. Thank you for watching this video. If you found this video helpful, please like, share and subscribe.